Well, I don't want to say that 11 judges of an en banc panel today in the Federal Circuit Court of Appeals against Donald Trump's tariff plan laughed out loud. But I will say that for 2 full hours of oral argument, Brett Shumate, who represented the Department of Justice in this oral argument to try to keep Donald Trump's tariff power intact under the International Emergency Economic Powers Act of 1977, he took on a lot of heat because most of the people that were up on the bench don't believe that Donald Trump has the power to impose tariffs at all, and certainly not under the IEEPA Act, which is the foundation of all of his tariffs and all of his proposed phony tariff deals. Let's get to it on Legal AF. I'm Michael Popok. All right, how'd we get here? Donald Trump announced in April in the Rose Garden he was going to impose tariffs on 170 countries, no less than 10%, and many even higher, 100% or more for China, now 50% for Brazil. And a lot of people at the time asked, how does the president have the power to impose tariffs when that is a power that's been reserved as a core constitutional function and it's reserved to Congress under Article 1? How does he get to do that? And he claimed he was doing it under a 1977 Emergency Powers Act passed during the Carter administration called the International Emergency Economic Powers Act, IEEPA, okay? Except for IEEPA, there's a problem with Donald Trump's scheme. You have to have a emergency and an unusual circumstance in order to impose it, right? You have to have an emergency and some sort of unusual occurrence that needs to be addressed through his powers. And it's almost always sanctions against foreign governments. Or if it is tariffs, they're very narrow tariffs for a very short amount of time, which are akin to sanctions. Okay, so what's the problem? Well, these aren't sanctions. These are reciprocal tariffs. That's Donald Trump's own term. They're to deal with a trade deficit. Now, the Trump administration looked the 11 judges on the panel. Let me tell you who the 11 judges are. As long as you're here, by the way, hit the free subscribe button. The 11 judges on this panel, which is the Federal Circuit Court of Appeals. It takes appeals from courts like the Court of International Trade in New York, which already ruled against Donald Trump several months ago. Now, this court, the specialty court of which takes appeals from all these other sort of specialty courts, it's made up of 11 judges, or at least 11 judges were sitting en banc all together to hear this appeal. 8 Democratic appointed judges, 3 Republican, 0 appointed by Donald Trump. Okay, so let's put that in context. And Donald Trump already lost at the Court of International Trade in New York. A 3-judge panel ruled 3-0 against Donald Trump, that he doesn't have the powers. Now, this court that he argued in front of today with oral argument at 10 o'clock this morning allowed Donald Trump to continue to collect the tariffs, his administration, while they were getting around to the appeal. So he's collected like $50 or $60 billion and he's been bragging about it. Now, side note, his Commerce Secretary, his family owns a business called Cantor Fitzgerald. Cantor Fitzgerald is betting against, so the Commerce Secretary's family business is betting against Donald Trump and tariffs because they're selling a product that says, hey, if tariffs get struck down as being unconstitutional or illegal, we'll buy your tariff overpayment now for real money, cash in the barrelhead, and we'll keep the difference. This is how much people in Donald Trump's own administration, and at least their families, think that what he did was lawful. Now, so everything you've been hearing that's been announced, the deal with, and he's listed all these, UK, and with Japan, and with Indonesia, and with the European Union, all not reduced to writing, all unenforceable. All these deals are illegal if this court that heard oral argument today says that they're illegal, up to the United States Supreme Court. And let me just say that the lawyer representing the Department of Justice, Brett Shumate, let's just say it was a hot bench for him. First of all, one of my favorite questions was asked by Judge Jimmy Reyna. And Jimmy Reyna is the first one I've heard point out that nowhere in the statute that Donald Trump is relying on to support any of his tariffs, nowhere is the mention of the word tariff, that he has the power to tariff under these emergency procedures. He has the power to sanction, for a unusual and an emergency-like event. Now, the Trump administration says, we were in an emergency. And the court said, well, what is it? They said, well, we went from $559 billion of trade deficit to $903 billion in the last 6 years. And they're like, that's not an emergency. That's an event. That's an occurrence. But that's not an emergency to authorize the use of these powers. Because Donald Trump's not only arguing that he has the powers to use these, that he has the power to use IEEPA to impose tariffs, which is really only for Congress, but he says it's unreviewable by the courts. Right? This is his common theme. It's an emergency. I have war powers. I have emergency powers. And the courts can't do anything about it because I'm the sole occupant of the Article 2 of the branch of government, and nobody can review what I have to say, even though that's not how checks and balance work. And so what the courts said, what the judges said today, including Judge Dyke, DYK, who was a Clinton appointee, he said, there's something called the major questions doctrine, which is if Congress wanted to give this level of power to a president, they would clearly express it somewhere in a statute. And nowhere in this statute is that expression by Congress that they want to give the ability for the president to just throw over all of the statutes on trade, all of the U.S. code dealing with the laws of the United States, because he said so, because of an emergency that's unusual, and he wants to impose these tariffs as sanctions. Nowhere does it say that. So the major questions doctrine is a problem for Donald Trump, as the court reminded him. Also, the judges said similarly, I don't believe that Congress would have intended for this to be used to rewrite the entire scheme and structure for tariffs and trade in America and have it be unreviewable by a court. That can't be the situation. Now, what does that mean for Donald Trump's tariffs? Well, he came off the Rose Garden, if you remember, with a 90-day, he hit the emergency brake. And then he said, well, no, I'm going to impose them. So right now, there's at least a 10%, somewhere on average to 16% tariff across the board, on average across the world. And then higher for certain people. And you're hearing about the quote unquote trade deals with the UK, with the European Union, with some aspirational, magical thinking about investments that'll never get made by Europe, by Japan, by United Kingdom, by Mexico, just announced today. All of that gets invalidated if this court, the Federal Court of Appeals, rules against Donald Trump in a majority decision. There's 11. There's no Trumpers. So it's going to be, based on my review of the 2 hours of the hearing, it's going to be 9-2, 8-3, could even be 11-0. And the higher the number, even though it only has to be a majority, the more power and weight that decision en banc has. Although the United States Supreme Court doesn't seem to care about the lower courts, even the ones at the federal circuit where some of these federal judges, some of these Supreme Court judges come from. And so I don't know what they're going to do with it. But this would now be, if I'm right, this would now be the second major court and major specialty court that deals with trade to rule against Donald Trump. He would have lost 3-0 at the Court of International Trade 2 months ago. He'll lose some high majority, supermajority number with this court, this federal court of appeals, a federal circuit court of appeals. And then it'll go up to the United States Supreme Court, not on an emergency docket. Although if this court rules against him, but doesn't continue their stay, that's the big issue I'll end the hot take on. Are they going to continue their stay? The stay meaning they have currently blocked the lower court ruling of the Court of International Trade in New York, which said we are tearing down your tariffs and all of your deals. That was stayed, blocked while they got up on this appeal. But once this appeal is ruled on, I really don't see grounds to stay it. Now, the Trump administration will ask for an emergency stay by this court to give them time to get to the United States Supreme Court. And then we will have a shadow docket emergency application to the United States Supreme Court this summer. So here's how I think it's going to work. We're going to get a ruling relatively soon. I don't know if it's a week. I don't know if it's a month. It's not days, but it's somewhere between a week and a month. We're going to get a ruling from this 11-judge panel. Somebody's going to write the decision for the majority, or it's going to be called per curiam, where it's the decision of all. And maybe if there's somebody that dissents, there may be a dissent attached to it. And then we'll have that wrapped up. That'll probably be by the time we roll into Labor Day. Could be before. And if it is, I'll rush right back here on Legal AF and report on it. Once that happens, they'll ask for that court to issue a stay. If that court doesn't issue a stay, they'll then file an emergency application to the United States Supreme Court. First stop on that train coming out of D.C. is Chief Justice Roberts. He will likely grant an administrative stay, at least for a day or 2 or 3 before he sets a briefing. Then he'll set briefing. He won't, in the meantime, the tariffs get collected and all of that. He'll then set briefing on an emergency basis. It'll be 2 briefs. The brief that the Trump administration files and the brief that, in this case, 2 cases combined. One case is about 12 states that challenge Donald Trump's powers under IEEPA to set tariffs, and the other one, small businesses. Those 2 cases will be combined. They'll give those people a brief, and they'll have 2 briefs. They may have oral argument. This is such a big deal. I would envision the Supreme Court conducting oral argument that we'll be able to hear. We'll put it up on Legal AF Live and do commentary at the time. That could be a September, October event. By October, we're rolling into the opening of the term for the Supreme Court, first Monday in October. So somewhere in there, after the Jewish holidays, I don't know, somewhere in there, there's going to be an oral argument. And then we're going to get a ruling from the Supreme Court 2 weeks, 3 weeks, 4 weeks, a month later. So before the new year, by the time the holidays roll around, we're going to have a ruling from the United States Supreme Court once and for all whether this president or any president under IEEPA can turn over the apple cart of congressional statutes about trade, take away Article 1 powers from the Congress, all because he says so, because he says it's unusual in an emergency. Well, my prediction, I don't think they go that far at the United States Supreme Court. I think they're consistent with some of the other decisions they've made. They'll say something like major questions doctrine. This is a major question. We need Congress to speak. They did not speak in 1977 in IEEPA. They didn't use the term tariff. If they wanted to, they could have. They didn't. And so we're not going to find that you have those war powers or those emergency powers to impose tariffs on countries. But of course, they're not going to want to upset Donald Trump. So there's going to be that push-pull that we're going to watch with the MAGA on the United States Supreme Court. We'll follow it all. So will you right here on Legal AF. So until my next report, take a moment, hit that free subscribe button. That's how you vote to keep us on the air. And now more than ever, we need your help. I'm Michael Popok. And I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.